Good morning. Welcome to Real Estate Know-How with Lynaae. I'm with Forbes Realty Group, owner and broker, and today I have my guest on, Alexis Brown with Alexis Brown
Law. That's correct.
And you say that, I like your little saying. You have a little saying.
My tagline, Alexis Brown Law, your champion for justice.
Champion for justice. And my tagline is finding a winning solution for your real estate needs the first time. So today I just wanted to touch base real quick. I've just opened up my own office. It's a great feeling. It's very empowering to be able to say broker owner, and I just love it. It's
Congratulations, by the way. That's so exciting. Congratulations.
I know, thanks.
And
it was a long time coming, but it's really cool because I actually had someone go, well, how did you come up with Forbes Realty? And my husband, being the funny little man he is sometimes, he can just come up with a quick quip. He said, because it was better than Trump. Now, that's someone
Good for your husband.
That's someone that's not paying attention to the names, because obviously if you have the famous name, don't you want to use a famous name?
Hello, you would think.
Yeah. Okay.
Built-in branding.
Yeah, exactly. So, Alexis, give us a little bit of background of what you do. How long have you been in practice? And what were you doing prior to getting into practice? Did you work as a paralegal? Did you work in as a receptionist?
Sure.
We all start somewhere.
We do. No, I actually have a long history sort of in the law. My parents were actually in law enforcement. So my dad was a police officer for 25 years, and my mom worked her way up from dispatch to deputy chief of detention out in North Las Vegas. Both of them were in North Las Vegas. So that's kind of what started it all, really.
Right.
And then during college, I worked in law firms. I was a receptionist. I was a legal secretary. I really did more than most of them would, because I knew I always wanted to be a lawyer. So, and then went to law school and continued working in law firms, and went to school at night part-time. It was really tough.
I always call that working in the trenches. You know, one of the things I did as a real estate agent, you know, I was first licensed in '89, and of course we're now giving away our age. And the funny thing is when we first get into real estate, there's nothing. I knew nothing. And I actually was lucky that the company that I started with put us through 2 weeks of training, hooked us up with the right title companies, the right lenders. And so really, literally, I would just take clients into the lender and drop them off. Now, after being in the industry, and I always say industry, I worked 5 years as a processor of loans.
Right.
Oh my gosh, what an eye-opening experience. It's like, how much more can I empower my clients?
Absolutely.
Because I can tell you how many times a closing hasn't happened because someone got so excited and went and bought a car. And we go, oh, oops, you have lending. You can't do that. You can do it after we close when I hand you the keys, but you don't. So not knowing that kind of stuff, now we prevent that.
Right. And having that sort of really fundamental background and seeing the back side of everything and really how the processes work and how to get from step A to step Z,
right,
and beyond even, really. I mean, if you think of litigation into appeals and those kinds of things, I mean, I've really seen every aspect because of all of the experience I have in every kind of case.
And I think it's great when we have that. And, and I don't mean to downplay the fact that what we've done, because, you know, I was a receptionist, and let me tell you what, that receptionist is my first person that I say their name, because you know what? They have actually a very hard job.
Absolutely.
They get some of the most grief on the phone for people not answering their phones, returning their calls, getting through to somebody.
Right.
Oh my gosh.
Right.
And they're not paid enough. It's kind, you know, so, and then I spent 5 years in what I called notary signing agent. And what happened is the title companies actually would contract me to sit in their office all day and sign loan documents.
Right.
And then what would happen during the down period, then they took me and taught me how to process the loan package back to the lender, how to set it up for recording, how to, you know, and then learn how to do the HUD settlement statement, which, by the way, no longer can real estate agents explain that. Did you know that?
I did not. Okay, so they're sort of starting to limit things a little more, or?
Yeah, well, we're a non-attorney-based closing. Okay, well, Georgia and Florida, and I know these states because I've lived in them, was attorney-based. We walked into closing. Everybody signed their paperwork. Everybody's monies were already at the escrow company, and then everybody exchanged keys, etc. And so that was that's your closing. Where here, people come in, 3-5 days before closing. Sellers can. And then the buyer now with the new TRID that started in October 3rd, literally they get their documents 3 days before, and now they actually walk in and they're funded the same day they sign, which is actually preferred to me, because it's like, how many times have we had delays?
So many times, yeah.
And the biggest mistake that lenders made was not being forthright with clients, and they get to the closing table and find out they need another $2,000 to close,
Right.
and the deal just completely goes undone.
Right.
So really, I think this process that we've now put in place is actually better
Absolutely.
for everybody, not only
Absolutely.
for the buyer but for the seller. Because how many times have we had sellers sitting outside their door all packed up,
Right.
and
Right.
everything failed?
Right. And I think that what you're kind of getting at is now, now there are getting to be more protections, in the process, which, if we're getting to kind of what we were talking about today, is that's what was not happening,
And now,
7 years ago.
We're going to talk about those HOA liens, and I know that the downturn started in about 2008, and then what would happen is people would fail to pay their mortgage, but then they saw that, well, why am I paying my HOA? And then, of course, the HOAs were going broke because people weren't paying their mortgages, and they weren't paying, and all of a sudden they found a remedy with one little line in the law that
An
even
important
the
line.
banks and the banks missed it.
Right. So just a little background. Of course, we all know our friendly HOAs, whether you love them or hate them. I mean, they do good things in a lot of communities, keeping them safe. I mean, in my community, I have, a roaming security guard, and that makes me comfortable. So I'm happy to pay my HOA dues. But in any event, if we're not paying our HOA dues, of course, the HOA is not running. It's not doing those things for us. So when people stop paying their mortgages, they also stop paying those HOA dues, because I guess maybe people figured, I don't have to pay anything now because the lender's just going to take the house.
Right.
Well,
What happened is, though, the lender got overwhelmed.
of course, considering how many loans failed in, from 2008 until
We're still having
now.
failures, because
Right.
I got a call this morning. I am actually doing a short sale, and that's another thing too. Just so you guys all know, I still do short sales. I have agents they're at offices with 1,500 people, and nobody does a short sale. That's not that hard to do.
No, they're not.
Okay.
They can be, a little time consuming, but yeah, they're not incredibly difficult. So they stopped paying their HOA dues, and the HOAs then turned these over to collection agencies, and the collection agencies started using the statute to enforce the liens that these HOAs had.
But
So what we're
unbeknownst to everybody, when enacting these statutes, one of which was talking about super lien position. Now let's just talk about tax liens real quick, because that'll kind of give us a little background of what happens when somebody fails to pay their taxes. Let's say it's not included in their mortgage payment.
right.
The tax lien company or the county actually informs the lender. So the lender now is on alert that tax bill has not been paid.
Correct.
And they can take one of two ways of remedy. They can pay it on behalf of the borrower, or they can get the borrower to take care of it.
Right.
Because in this state, it's also a super lien position.
Correct.
And so if it winds up in going into lien, the lender is wiped out.
Right.
So, but there's a lot of things in place, though, that protects the lender in a thing like this. Did we have that kind of protection in place for lenders when the HOA happened?
Conceivably there was, because lenders, they have the first trust deed. So they're thinking, we have this first trust deed, and that means that we're in front of everybody else. Well, there's this little line in the statute that says when HOA dues are not paid, the HOA can essentially assess a lien against the property for all of the assessments that are due.
And they do.
However, there's a little line that says that 9 months of assessments
Is all
has
they could collect.
priority over everything else, essentially. There's just, so even including in the statute, even including the first trust deed. So 9 months of the assessments, it can be a very small amount, thousands of dollars, a couple $1,000s.
And we have a case that happened in September of 2014 that the HOA put to auction a $6,000 HOA lien.
Correct.
And it essentially wiped out a $700,000 loan.
It did. So in that case, so an investor bought the house. This SFR Investments case. They bought the house at the foreclosure sale, the HOA foreclosure sale, foreclosed on its super priority lien, and the bank later
came back and
tried to foreclose on its mortgage.
Right.
Because the bank said that the investor took title subject to the mortgage. So the bank says, you still owe us the money, you didn't pay us the money, now we're going to foreclose on you. Well, the investor says, no. I actually bought off of a super priority lien that wiped out everything else, because that's what happens. When you foreclose on a superior lien, everything junior to it is essentially wiped out. So if you have a first deed on your house and the first lender forecloses, your second is wiped out, if you have a third, etc. So that's essentially what's going on here.
So let's take a deep breath and for a moment. We're going to give a call-in number, because I think that this might, I don't know if this is a hot subject for people, because I know solar was. Okay, so 702-483-4444, 702-483-4444. Real Estate Know-How with Lynaae, and my guest today, Alexis Brown. And we're going to just take a small break, and we'll see you at the next turn. Good morning, and welcome back to Real Estate Know-How with Lynaae. Forbes Realty Group. We are a local real estate company here. We still do short sales, do probate, your regular sales, your regular traditional real estate. So don't forget, if you want someone who knows what they're doing with 25 years of industry experience and a lot of support with attorneys. Because this morning I got an attorney lead for a short sale. And then I want to welcome Alexis Brown to my show today. Thank you.
Of course.
So
happy to be here.
This is exciting, because I know that for you know that you went through a lot of schooling to get to where you're at.
I did, of course.
Yeah, but rare is it that you find agents that have the background that I have.
Absolutely.
And I say this because a lot of people forget that it's too easy to get a real estate license. It's 90 hours to get your license, and then 30 more hours the first year to maintain the license, and then thereafter it's 24 credit hours every 2 years.
Right.
So often the only thing we need is a GED, a high school equivalence. But it's like when I go to my nail artist, they put in 1,500 hours. And I cringe a little bit, because they're not touching this great big asset like an agent is.
Sure, and there's a lot of technical documents and things. And that is not to say anything against anyone who goes through and does it the traditional way, you know what I mean? All respect to anybody who does. But, you know what I mean, yeah, having the background that you have is incredibly valuable to your clients. I know that.
Right, and so that's what I sell. You know, people ask me what makes me sets myself aside or sets myself apart from my peers. Well, the biggest one I always say is why am I selling real estate? Because I grew up in the foster care system, and I always believe that everybody should have a home.
Absolutely.
I didn't have one as a child.
Oh, that's beautiful.
And so,
that's beautiful. I love that.
So it's like, you know, there's my why, but then there's that other part that just like actually just happened with, you know, I call it osmosis, because I got the privilege of working with title companies, and I've worked with several around here, and I got to do something yesterday which was really cool.
Yeah.
We got a offer in on one of our properties, and the title company was chosen by the buyer, like it should be. Okay, I'm going to say that, like it should be. And the title company asked me to change my listing to show them as the preferred title company, so that everybody could get 10% off. And I wrote them back and I said, it's the policy of Forbes Realty Group, LLC, that our listings do not direct title.
Good for you. Good for you.
And then you know what? it doesn't matter if it's 10 or 30%. If the CFPB comes into my office
Right.
and they pull my listings,
The fact that your real estate agent wants to look fair and equitable in all of your transactions is such a quality that you really need in a real estate agent, because it's such an important, it's having a title company is such an important thing, because you're neutral and you don't want them to ever look
thank
partial.
you. And it's so funny because when the title companies pull up my stats, they always say, well, Lynaae, you have no loyalty. And I'm like, because I'm not supposed to. You're the third party disinterested in this transaction. I am not supposed to have a close relationship with you to the point where you would favor my side over the other side. That's not your job.
Not only that, but you also have options. You know what I mean? You give your clients options. You're not working with just one company who, really, in the grand scheme of things, I think it's better. You have options, and you can say, this is who I've had good experience with, this is who I've had better experience with, and you can choose from there.
Exactly. And so we're working on putting together a book to hand to the client so that they can call on these title companies and get their fees, et cetera. What I love, though, is if I get into a situation where they do pick the title company, because I've worked with so many different ones, I actually have escrow officers every one of them. So
which is great.
If I know an escrow officer isn't a good fit, I can actually request the escrow officer hereby not choosing the title company.
Right.
So that's why I like what I do with you. I think that being fair, playing fair also comes back. So let's talk about that playing fair part.
Sure.
The lenders came in 2014, and they said, "Oh, boo-hoo! We have the biggest loan, and we're entitled to get that back." And the court said, "Oh, but you had remedies."
Right. So
what were some of those remedies?
Sure. Well, the HOA has to provide notice, of course, of its HOA
but what
sale.
if they didn't? What if the lender didn't record that so-called notice document? Because that's a requirement of the lender.
Sure. And if the lender didn't do what it was supposed to do, they can't come into the court. There's sort of this clean hands kind of thing. Not exactly on this issue, but in a sense, it's kind of that, where you're coming into court and saying, well, I didn't really do everything right, but they have to. And the judges don't really like that. Court doesn't really like that.
Oh, no, they don't like
so
that.
the court says, well, the HOA did what it was supposed to do. You didn't, and you didn't pay it off. You didn't,
You just sat there.
didn't come in. You kind of sat on your hands. Well, in that case, yeah, your mortgage can be wiped out. Your deed of trust can be wiped out. Your rights to be paid can be wiped out. And so that was a pretty big decision, because I think a lot of people were thinking, and even myself, I can see both sides, where the lender, is in this first position, and, maybe they should be taking title subject to that. I can see both sides of it, but the court ruled that if you sit on your hands, you're in a little bit of trouble.
Well, yeah, because you did have remedies. You could have filed that document, which would have required the HOA to inform you that there was no payments being made on the HOA.
Right.
And now they turned it into collections. Now they don't have the money to maintain the common areas of the properties in that area.
Right.
Make people stick to the right colors of their house. All of a sudden you walk into a neighborhood and it's pink or really bright blue.
Right.
Smurfs are not allowed. That goes a long ways, because that's the integrity of keeping the property up. Just the simple fact of keeping your palm trees trimmed. It's not a matter of really what it's actually safety, because rats get up in there.
Right. And you could fall and all of those kinds of things, of course.
So there's all kinds of things that the HOA does do. Yeah, there's a few of them out there where somebody has nothing better to do than drive around the properties. And then I got noticed one time because
report your weed.
They reported my weed, and I looked down the street and I said, so what about that guy with all the newspapers in front of his house that haven't been picked up for months, weeks?
Yeah.
And then they finally did something about it. And I was like, so, you don't have that clarity. You don't have the fairness sometimes. It's like you get kind of picked on.
Right. So some HOAs are unfortunately the management companies is what it is. Sometimes they get a little overzealous, I'll say that.
Yeah, they can be.
They can be, but I think overall, it's something that needs to be paid.
Right.
You go into a house knowing that there's an HOA and knowing that you have dues, and the bank knows also that there's an
Yeah, there's a
HOA.
document on your deed of trust that's added as a rider.
Absolutely. So the bank knows that it's in an HOA. So, the bank should be, under some obligation to say, come in and say, what, I'll pay it off because I have an interest I need to protect. And then, it essentially comes into that first super priority position because it paid off the lien.
Okay.
The HOA lien.
So now we had another case that was reverse of that, though. The HOA refused to cooperate with the bank.
Right, and so yeah, that's kind of the other issue that I think some banks were facing, is some banks were trying to do their due diligence, and they
I
were
know, I
trying
was
to,
part of it.
right, and yeah, and
I shared a couple of stories with you.
yeah, and agents were coming in and trying to, make sure that these liens are paid off right and those kinds of things, and what was going on is some of the collection agencies were getting really.
Greedy?
That's a good word for it, I suppose. As good a word as any.
They were getting greedy.
Right,
because
and they were charging lots and lots and lots of fees on top of the assessments, and just some of them were a bit extraordinary.
Well, yeah, I had one
them.
bill that literally their monthly was like $25. They were late 6 months. That 6 times 25, that turned into a $5,000 bill.
Because of all of the,
Yes.
late notices and those kinds
And so
of
you're
things,
just
yeah.
like, wow, you've just overwhelmed the homeowner who is already distressed. And now you're adding that added insult.
Right.
And then lien holders are going, well, that's just too much money. But by the way, we forgot to file that document anyway.
Well, and I think part of the problem is, and now the legislature has spoken on how much can be charged for these things. So that was, I think, some of the issue is there was no clarity, there was no indication anywhere as to what could be included in the lien and how much and what was reasonable, what was not reasonable, those kinds of things. So it was just kind of willy-nilly, wild, wild west out there for a minute, you know what I mean, as far as the amounts.
I actually was able successfully with one major servicer, and it wasn't a bank, it's a servicer. There's a difference between, just so you know, Bank of America is a bank, but they're also a servicer, but there are banks out there that are just servicers. They don't have a brick and mortar where you can go in and open a checking account or a savings account. So the servicer on this particular file, I was not giving up for my clients because I knew the moment that HOA lien got sold that they would be evicted by the person who purchased the HOA.
Right.
And my borrower would still be liable for the mortgage.
Correct.
And so that's where the real estate agent really needed to come in and say, we need to stop this. And I actually did do that on 3 occasions. I got the lien holder to pay the entire HOA lien. But I got the 2 parties talking, so then I got that taken off the trustee sale thing. But that was a lot of work.
I'm sure it was.
And I got nothing for it except that I saved my borrower, my seller, from being kicked out of their house.
Right.
Because they had failed to pay their HOA.
Right. Yeah, it's when the collection agencies were getting involved, the collection companies, and some of them, again, were just so overzealous, and that's where some of the issues have come up. And so again, the banks were trying to do what they were supposed to do. They were trying to pay off these HOA liens and getting that resistance. And then so the HOA is foreclosing anyways, and the bank comes in that case and says, wait.
And
they
now
should not have done that. We were trying, and now they're going to say, now there's this new purchaser who's going to say that my lien doesn't exist, and we tried to do what we were
Here's
supposed to do.
something that's interesting too. Once these investors figured this out, did you notice how a $6,000 HOA would get sold for $20,000? Or $30,000,
Sure.
or $40,000. So the question then goes back to, well, what did the HOA do with the excess funds that they gained?
Sure, and really that should go to the first trust deed holder. So it should go in order. I mean, if there's a tax lien or a real estate tax lien, that's going to get paid first. If then there's the super priority portion of the HOA lien, that gets paid next. Then whatever would go to the first trust deed holder, and then so on and so forth. You know what I mean? And so, yeah, I guess in some cases, yeah, the HOAs or the collection agencies were saying, well, actually our whole lien is X number of dollars, so we're just going to keep all of this money, when really that's not how it was supposed to be working. So that's another problem that the banks were looking at.
And we're going to be seeing some unwinding, especially any of these that got sold under what we called FHA, Fannie Mae, Freddie Mac,
Absolutely.
or
Absolutely.
VA, which are what we call government-backed loans. They're not subject to the super priority lien.
Well, in a way they are, but the thing is the when an HOA forecloses, the mortgage stays with the house.
Right.
Regardless. Where if it's just a traditional loan from, your Bank of America or something like that, that can
conventional.
be extinguished, whereas a government-backed loan cannot be because federal law trumps the state law on that.
That's what I heard.
Yeah, that's what the most
And that was,
recent
it
is
was
on
funny, right after that September 2014 ruling, right after that in October, another ruling came down on the federal part of that, and that said, yeah, that might be so, but don't even think that's going to happen with these federal liens.
Right, and so yeah, the federal court really what they kind of ruled on in between there was that the prior ruling that did extinguish the first trust deed holder, that one didn't really have retroactive application, meaning that there's all these cases in the meantime. We didn't really know that this would ultimately be the outcome under these circumstances, so we're not going to enforce it against everybody else. But going forward, any foreclosures that happened after that, yes, it will apply to that for sure. But also that these equitable reasons can unwind your HOA sale. So you have that ability to do your HOA foreclosure sale. You have that ability to do it still.
So in our next portion, we're going to talk about what happened just recently in February of 2016. So this is Real Estate Know-How with Lynaae. I'm with Forbes Realty Group, LLC, broker owner, and our call number is 702-483-4444. Look to see you around the next corner. And good morning. Welcome back to Real Estate Know-How with Lynaae. I am Lynaae Forbes with Forbes Realty Group, LLC. We just opened in January, and I am excited. Today we have our guest, Alexis Brown with Alexis Brown Law.
Your champion for justice. Good morning.
See, just love
And your favorite Vegas ginger lawyer.
it. Now, how did you come up with ginger lawyer?
I'm a redhead, of course.
Oh, I was wondering about that because it was black and white, and I didn't see that. And I was like going, where did the ginger come from? Now I got the rest of the story.
Yes.
That Ginger Rogers.
That's, you gotta have a good ginger in your life,
Oh, that is so cute. Okay, so today we were talking a little bit about the HOAs and the super liens and how all of that has just shook out in this market and really caused a lot of confusion to some point where some of the properties that were bought under the HOA can't even get title insurance because there's still a lot of unanswered questions. And even with this last ruling in February, actually in January, but we got more of the write-ups on it starting in February, like the 2nd or so, that talked about what's reasonable. Can you really buy a house and under a super lien position for $6,000 when you know it's worth $700? And that's what really started this whole being in court in the first place, because these people really thought they took the bank, which the bank goes, no, you can't take the bank. And
in some cases you can, but it just,
this is a case where they felt like this is not reasonable. You can't really truly fit. And here's the thing. The investors hadn't figured out at that point when they were doing this that this was happening. And so we were only seeing people buying the actual lien itself. And then when it got into the market, we saw something happen. People were paying more than the lien.
Right.
And in some cases, that's why, when we talk about tax liens, that people will willingly pay on a, $3,000 or $4,000 lien, $100,000 if the property's worth it.
Right. So we're looking at fair market value. That's really the issue.
And that's where this new ruling comes in.
Right. So yeah. So this more recent ruling from earlier this year is a case where the bank attempted to pay off the HOA lien. There was a dispute over the amount. Again, all these sort of excessive additional collection fees and those kinds of things. Could it be included? Well, the HOA ends up foreclosing. They don't come to an agreement. The HOA forecloses. So the bank says, the bank challenges the sale, essentially. Bank comes in and says, this was not a reasonable sale. They should have done it for fair market value. They didn't give us all the proper notices, all of those kinds of things. So the lower court found in favor of the bank.
And I can see why, because the bank was involved at this point. See, if you're talking to the bank, I had a little black lady. She was so cute. We went into court in front of Judge Delaney, and the bank kept telling her that she wasn't eligible for mediation. And what did Delaney ask? She goes, so Miss Georgia, I'll just use her first name, Miss Georgia, so tell us what happened. She goes, well, the bank called me and they sent me notices in my name, and they told me to go to probate and follow the probate procedure and get the property, take care of the will.
Right.
And Delaney took one look at that and she said, well, someone's got to speak for the dead. And so she ruled on behalf of this borrower, or excuse me, the heir to the estate, and basically said to bank, which was a big bank, you can't do that. You cannot engage someone and then come back in and say they can't do that.
Right. So, yeah.
So this is kind of one of those things where they're saying, hey, you engaged with us. We couldn't come to an agreement. And so you just played hardball and you went ahead and foreclosed on the property.
Exactly. So the bank, everybody filed motions for summary judgment in the case. The court found in favor of the bank, set aside the HOA sale, and basically gave the house back to the bank. Well, of course, everybody, the HOA appeals, goes up to the Nevada Supreme Court. And so the Nevada Supreme Court essentially said that, first of all, confirmed, as if it was a question, that the court can consider these types of actions by the bank. Okay, so I don't know why that was a question, really. I mean, of course, the court has equitable powers. It can do that.
Right.
But really, sort of the heart of it was that, that these HOA sales, they do have to be done reasonably, meaning that the house should be some percentage of fair market value when it goes to these HOA sales. They kind of suggested a roundabout of a 20% number. That's not, dead on. It's not a hardline rule or anything like that. But yeah, a $6,000 purchase at an HOA foreclosure sale for a $700,000
house. Oh, please.
That's not really reasonable.
No, that's not reasonable.
In a case like that, I could see where they could unwind that HOA
and
foreclosure.
when these investors figured this out, they started going and bidding on these, and that's when we started seeing an uptick in the HOAs getting more than what their actual lien was. So I find it very interesting, though. So now, as a real estate agent, one of the first things I look for, because I worked in title, I actually look at the county recorder's office and all the stuff that's recorded against a property. And so you can see where the HOAs have done their notices of default. They've done their trustee sales. They filed the lien first.
Right.
So the bank really didn't know type of thing if they're doing their proper work, because what would they do if it was a tax issue? That's why we do impounds. I don't foresee, though, that they're going to start impounding people's HOAs and SIDs.
I would think not, probably not.
No, but again, like I was telling you during the break, one of the first things I noticed right after the September 14th hearing, my bank actually filed that document called notice. That means that if they notified the HOA that if I fail to pay, the HOA is obligated to notify the lien holder.
Right, and really, when you're doing a foreclosure sale of a lien with priority, you're supposed to notify all of the juniors lien holders anyways. So if the HOAs were not doing that, really, they weren't doing it right. You know what I mean? Although it wasn't spelled out specifically in the law like it is now. You know what I mean? With Senate Bill 306, or I think it was Senate Bill 306, with that, it's specifically spelled out in there, but they should have been doing it anyways.
There's more burden on a mechanics lien to get paid than there was on the HOA.
Right. I mean, under the statutes, yeah, there was more before there was more spelled out for mechanics liens to foreclose on their liens than there was for HOAs.
And that's what some people were bringing into this mix was, hey, by the way, mechanics lien is, materials and labor, and they have to go get a judgment. That means that they have to take the homeowner to small claims court and get a judgment against them before they can even file their lien. So that's a public record.
Not exactly. They file their liens before they can enforce it. Before mechanics, material men, those kinds of people, construction companies can enforce their liens. They do have to go to court to do that, unless they can get it paid off, of course, which is the idea. But for an HOA sale, they're allowed to do non-judicial foreclosure sales. So that means they don't have to go into court. And the banks were pretty upset about that.
I can agree with that.
In ways, I can see that. But considering when your lien is only $6,000 and you have to go into court and pay $25,000 to litigate over it, you know what I mean? I think that the legislature was maybe trying to enact some fairness and balance there.
But they could have used the small claims court, because small claims court's up to $10,000. So they could have utilized that.
But when it's title to property and those kinds of things, you usually have to go into the district court.
Ah, okay.
So you know what I mean? So you're actually in a more expensive court and you're going to spend more money. So I think that that's maybe where the legislature was initially coming from on that.
Got it. Okay.
It's to say, we'll get them some money and they don't have to go through this onerous judicial process. But again, you need to now better be notifying the banks. Otherwise, you're going to have issues later on with title and those kinds of things.
Yeah, and that brings up that title issue, because now we've got a cloud on the title because it's an unaddressed issue, and because the banks are actually fighting back, and title companies are going, I'm not eating that $700,000 home loan that the HOA basically wiped out.
Right.
So we're not going to insure this.
Right.
One of the things that I did hear was happening, and I could be wrong, is that these HOA guys were now going, okay, we're going to wipe that out, but now I got to get a clean title so I can sell the property. So they now try to do quiet title action, and what we were finding is that there was another ruling that came down that I understood is that what is service? And so servicing the homeowner that you displaced,
right?
You can't just do it by FedEx.
There's lots of cases on service in all kinds of issues, in lawsuits. But yeah, I imagine that would be an interesting question too, is if you're serving the homeowner at their last known address, which is the house that they now don't live in.
Because you evicted them.
Is that proper service? Is that proper notice? Under due process, I would argue as the homeowner's attorney that maybe it's not. You know what I mean?
Well, and I've already heard some of that fight back too.
Yeah, I'm sure.
So that's where the title companies are coming in going, yeah, you might be trying to get quiet title action, but we're going to look at how you did it. And we don't care if the judge ruled in your behalf. If that service wasn't given directly that's their position, because they got to protect their insurance.
Of course. I mean, that's, they're not in the business of actually paying off all the mortgages. They're just in the business of ensuring that you have good title.
Right. So, my last show, we had a gal in here from Harmony Title, and I thought it was really
St. Jacques.
Yes. And we were just discussing some of the different things of what title covers.
Right.
And that's been a big hang up. And as a matter of fact, the MLS, which is the Greater Las Vegas Realtors Association, they won't allow agents to list a home if they know that it was purchased through an HOA lien process and has not settled with that mortgage holder.
Interesting. And that makes sense. I mean, because the MLS,
we can't get title.
Right, exactly. You're not getting in title insurance. You're not getting actually what really is a clear title, because there's still these questions about, is the mortgage there? Is the mortgage not there? Who's supposed to pay it? Who's not supposed to pay it? Well,
and some of these people who did purchase some of these HOA liens were actually smart. They went to the bank and negotiated with the bank, and they actually settled with the bank. Some of them did the purchases just to do that, so that they would have first position to buy and flip that property.
Right.
So some of them had a good strategy to say.
Well, sure, you can walk into a negotiation and say, well, we could fight about this all day long. There's 1,000 other cases in the court system right now. Or I'll pay you X number of dollars and actually own this house free and clear.
And it depends upon where the bank's position is too, because they actually have more money than that investor.
Of course.
So there's going to be a push back and forth.
But it does give you a little bit of leverage when you can go into a negotiation with that.
Right. But if you go in knowing that if you go in and go, here's the property value of the distressed property, because when I have to deal with an HOA, the first thing I learned from the BPO person is no, we can't use other distressed properties to compare your distressed property.
Right.
That's unfair, because it is a distressed property. which has deferred maintenance and probably has an HOA lien and a trash lien and all that other stuff going on.
Right.
So we all forget that, the banks, they have these rules that they try to follow, but the problem is you can't compare my distressed property or that listed distressed property with a flipped property that's move-in ready.
Right.
So that's our new battles. This is something these guys got past. They didn't have to deal with that because they could come in and say, well, we're buying it. It's a distressed property. You want your money. We want to move on.
Right.
So now let's come to an agreement.
Right.
And some of them were smart enough to do that.
Right.
So, okay, so this was exciting. I was like, we're just flying today. So we're going to come back on after the break and wrap it up a little bit. But I am with Alexis Brown with Alexis Brown Law.
Your champion for justice.
Lynaae, Real Estate Know-How with Lynaae with Forbes Realty Group. Our call-in is 702-483-4444, and we'll see you around the corner. And good morning. Welcome back to Real Estate Know-How with Lynaae. I am Lynaae Forbes with Forbes Realty Group, LLC. We opened in January, and so excited today to have on my show guest Alexis Brown with Alexis Brown Law.
Good morning. Thank you again for having me. I really appreciate it. It's been fun so far.
Oh yeah, we've just flown through this. Haven't we?
It has.
Well, I think it's nice when you can talk to somebody that has some knowledge about what we're doing today.
Yeah, I agree.
You and I both are very knowledgeable, but I take pride as a real estate agent. I can't advise my clients. I can't be an attorney, but it is my job to inform them. And by informing them, then what I've done is I've basically set the table and said, here's some really great questions to ask your attorney.
Right. Exactly.
Because if you want to look smart and you want to get to the meat of it, sometimes people are just looking like deer in the headlights. Well, what do I do?
Well, it's a hard process. I mean, and it is, it's a technical, legal, confusing process sometimes buying a home. It can be, especially if that is not your background.
Exactly.
And so it is wonderful to have an educated and informed real estate agent who can, just give you some information and direct you to the right places.
And that's my job.
Exactly.
Technically, that's my job. It's like I've always said, I come from the apple capital of the world, Wenatchee, Washington. I was born and raised there. That's where most of my foster care homes were in. And one of the things that I love to tell people, it's how I explain investing. Okay, I can give you a Golden Delicious and a Granny May, and I can explain to you what each apple is. By the time I'm done, I should be able to ask you a simple question. Which one would you use in a pie?
Right.
Now, if I've explained that apples correctly, you're going to pick the Granny May.
Granny Smith, right.
The Granny Smith,
right.
Because every time the Granny Smith is that type of apple that's great for apple pie. Well, it's the same with talking about vesting, community property with rights to survivorship, and joint tenants. And community property with rights to survivorship didn't come into play until 2001. And yet we still have title and lenders who keep putting our married couples into joint tenants automatically.
Right.
Well, if you're going to make a freaking mistake, at least make it
informed.
Joint tenants, don't do it, because the joint tenants was actually the lazy man's, it's the poor man's will.
Right.
And what it was is the married couples were community property. They had to have a will. Well, they figured out joint tenants kept them out of probate court. So they went and did that.
Of course.
But then there was a great big tax implication that went with that from the IRS.
Right.
Okay? So they came up with this, but yet we've got the title people and the lenders still uneducated about that.
And it's when you're doing things one way for a long time, a lot of times people get stuck in that, and they forget that we need to think outside of it.
So as a real estate agent, my job is to make sure, first of all, that my client has those choices, and that if they're not explained, either explain them. There's a document out there on the internet that explains them perfectly that I give everybody.
Right.
And then I like to do picture shows, so I write up little pictures and show them what these really look like in real life. And the next thing you know, people are going, oh, well, I'm married and I don't want to go to probate and I want to protect my tax. Oh, so I should do probably community property with rights to survivorship. And I'm going to go, ding, 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 you got it right, because I didn't advise you. I didn't tell you. Okay, but that's the difference between myself and you.
Right, I can tell you.
You can walk in her office. She goes. She doesn't have to.
This is what you need to do.
This is what you need to do.
Right.
But the funniest thing that ever happened to me was I did that little thing in front of an attorney that I didn't know was an attorney, as a notary signing agent. And the next thing I know, he's picking up the phone and go, blah, 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 blah. And the guy goes, that's the one you want. He looked, he goes, well, you're not going to believe this. The notary just explained this to me.
That's fantastic, though. You know,
Yeah,
that means you're doing it in the right way and you're explaining it well enough. That's awesome. That's
And so
what you need to do.
that's why bringing you today into the show, I want people to know that I have access to great information, great authority. When I I've set them up, they come in there asking the right questions. You're going to go, wow, this is going to be simple because Lynaae's already explained it.
Absolutely.
I'm gonna have this stuff to back it all up, and that's what we really want to see.
Right. Well, and the great thing is, I mean, I think, with you now that you're, especially as a broker owner, I mean, you're probably going to need a person like me even less and less, which is fantastic for you.
More and more.
Well, in some ways, but but when it comes to your specific transactions, I doubt you'll need an attorney to step in at all.
And that's because the state has given me the authority to fill in the blanks,
right,
and not play attorney, because that's what I always find really interesting. I've had a couple of cases where I've not talked to the agent after they brought me in an addendum because they've rewritten the contract and they unintendedly undid something.
Right.
It wasn't their intention, but it was the fact that they were playing attorney. And
right.
So when the broker finally called me, I went through the list and they go, well, I wouldn't have signed that either. Thank you. So that's where my job comes in,
right,
is to protect my client and their position, but not play attorney.
No, absolutely not. I mean,
and make sure that agents aren't playing attorney.
Of course, and especially as a broker, you need to be making sure that your agents are doing that.
And that was, so that it was really, it's interesting to do that. So I think that you and I, as a partner in our business, because I know you do real estate transactions as well.
Yes, I do.
And so I want to welcome you to my office, and I do want to talk to you about getting some things set up, because as a business owner, one of the things that we do have to do in a litigious type of situation is make sure that we are following the rules and making sure that other agents are adhering to it. So it's like yesterday when I got that email and I said, no, our office does not direct title on our listings. However, I can on my purchases. And that's because I'm educating my purchaser the same way they would go out and find car insurance or house insurance, any of that kind of stuff. But they're going to go, well, which ones work the best? I'm going to go, well, here's the top 3 in my book, but here are 5. You're welcome to call. And they'll look at me and go, I want that one because you said that. That's fine.
Right.
But at least they had those 5 choices.
Absolutely.
Okay? At the end of the day, that's what I want to be known for, is being fair and being on point with my clients and making sure that we're all following the rules.
And I try to do the same in my practice, of course. As far as making sure that I'm treating my clients fairly, I think some attorneys, unfortunately, don't always with their clients.
Or they leave out that little loophole that they didn't have to explain because they'll bring it back business.
Yeah. I don't know about that. I don't do that. But no, I try to make sure that I'm, fair. My rates are fair. And I make sure that I'm practical with my clients, too. I'm not the kind of attorney that's going to go out and litigate every issue to the hilt if that's not what's really practical for you,
Mm-hmm.
So that's what I try to do.
Okay, very good. Well, I think we're coming to the end of our show. I wanted to thank everybody for tuning in today.
Thank you
I want
so
to
much.
thank
Yes.
Alexis for joining me. I feel like we were the synergy going on here.
Yeah.
But you and I are part of the Las Vegas Empowered Women, and we've had Magdalena on our show. She's our guru of feng shui.
Yes.
So again, thank you for joining us. Real Estate Know-How with Lynaae Forbes Realty Group, LLC. I am the broker and owner, and I welcome you to call me at my office at 702-743-7797. And what's your phone number?
702-581-1494, and you can call or text.
Oh, that is great. And mine is also text as well. So again, thank you for joining us. Have a great day and have a great week.